We now come to another interesting aspect of freedom of speech, which is freedom of press. In 2 or 3 judgments, our courts have again leaned very heavily in favor of the press. First important judgment is a judgment in Sakal papers, which is a 1962 judgment of our Supreme Court. And there the question was as to a particular central government policy which restricted the price that could be charged by a newspaper per page of its newspaper. And it was said that it was done in order to prevent monopolies. So the idea was that we want the bigger newspapers to be cut down to size so that the smaller newspapers would rise. The Supreme Court would have none of it. Supreme Court specifically observed that this is a direct interference with circulation, because the moment you bring your price down, you would necessarily have to bring the number of pages down. And if you bring the number of pages down, then you are directly interfering with freedom of speech and expression. And they therefore struck this down. The other important observation they made was that unlike other fundamental rights, which are subject to laws which are made in the interest of the general public, 19.2 has no interest of the general public. It has these 8 heads under which you either fall or you do not fall. And since you do not fall under any of these heads, namely the creation of a monopoly would not fall under any of these heads, freedom of speech is unrestricted. Similarly, several years later in Bennett Coleman's case, where my father as Additional Solicitor General, a very young Additional Solicitor General, appeared against the great Nani Palkhiwala and tried to defend a measure similar to that in Sakal. He at least managed to get one judge on his side, Justice Matthew. So it was a 4-1 judgment. And essentially, that judgment dealt with a newsprint import control policy. And there the import control policy was not on price, but on the number of pages, the newsprint that you could use per newspaper. So it said not more than 10 pages. This was struck down on similar grounds as the Sakal papers case, saying that circulation is everything when it comes to freedom of expression. And if you are curbing circulation, you are going at the heart of free speech, because the newspaper ultimately is the watchdog of democracy in that it prints things that people, that masses of people read and masses of people get influenced by. In the United States, in another very important judgment, which has been repeatedly followed here, New York Times versus Sullivan, 1964 judgment, by the arch-liberal Justice Bennett, the question was whether newspapers could be held to damages for defamation. When somebody said that, look, you have said so-and-so about me, and it's not strictly correct. The American Supreme Court bent over backwards to protect the newspapers and said that unless there is actual malice, and by actual malice what they meant was that unless you know that you are printing something utterly false, or you have such reckless disregard for the truth that we will assume that you know that you are printing something false, the newspaper is protected. And this again we follow in our country. So you see how case law has developed freedom of speech and expression, and how ultimately it is so important that there be this huge circulation of ideas among all of us, diverse ideas. The whole object is that the idea be diverse. When we come to 19.2 and the curbs on freedom of speech, as I told you, you had those 8 subject matters. But the first thing that you had to do was you had to pass a law. Executive action won't do to curb speech. Second thing that you have to do is you have to see that the law is absolutely necessary to curb speech. If there's some other less obtrusive method That has to be followed. And of course, it must have some direct proximate connection with one of the 8 subject matters. If it falls outside the 8 subject matters, again, out to go.